Hello, everyone, and thank you for joining us once again, and welcome to those who are joining for the first time. My name is Sarah Longcar, and I'm ACSI's Learning and Development Manager. Every week, we're providing this legal legislative brief with our team here at ACSI. We'll begin by providing you with a report on the latest changes that have come through, and then we'll spend the final portion of our time together in Q&A. Before we get started, we'd love to know more about who is joining us today. So we would ask that you would just take a moment and fill out the poll that is appearing on your screen at this time. And with that, I would like to turn it over to Dr. Tom Cathy.
Let me go ahead and I'll open us up in a word of prayer. Father, we do thank you for this day. We thank you for this opportunity to be able to gather together, Lord, and just look at some of these essential areas, Lord, to help our schools understand the things that they're able to do during this crisis time. Father, help us to be clear in everything that we say, and that, Lord, we could answer questions to be able to help our schools. Father, thank you again just for this time together. In Jesus' name we pray. Amen. As we mentioned today, what I'm going to do is I'm going to introduce in just a minute George Triffiati's our Director for Government Affairs, and he's going to talk about the CARES Act and the equitable services. We did talk about that last week. He's just going to give you some new updates and some clarity as we continue on that area. I'll give you some continued updates on the Families First Corona Response Act. There's a few things there of clarity, and then some clarity on the personal protection, paid protection leave, and the loan there. And then Philip will come on, and Philip's going to talk a little bit about the religious liberty issues and state issues. There's been a lot of questions about the CARES Act and are there strings attached? And we mentioned some of that last week, and Philip will be sharing that today with us. So let me move on and just remind you that, of course, our department, we're not lawyers, and we try to give you information based on the law and on the subjects we're going to talk about. But if you really want legal counsel, you need to be sure and talk to a lawyer for that. I want to also remind you that we have our special legal legislative coronavirus resource page on our ACSI website, and everything that we'll talk about today, you'll see all those new yellow highlights. Down below, you'll see a couple of them that are the purple there that say updated. Everything we talk about today will be in one of those documents that's marked highlighted or new by ACSI. So with that, I'm going to turn it over to George Triffiati. George?
Thank you, Tom. Greetings, everyone, from sunny Washington, D.C. My job today is to give you a big picture and then get into a little bit of the weeds with respect to how some of these emergency funds are going to be dealt with. So let's go to the next slide. The CARES Act, first is the big picture. CARES Act passed, you know that. It created an education stabilization fund. It has $30.75 billion in it, and it's going to be distributed into 3 different specific funds. Number 1 is the Governor's Emergency Relief Fund. Number 2 is elementary and secondary, and number 3 is higher education. The 2 we care about, of course, are the Governor's and the elementary and secondary school emergency relief funds. So those 2 are the 2 hot buttons for us. Next. The 2 funds in the Education Stabilization Fund that apply to our elementary and secondary schools both require that the local education agency, the LEA, make equitable services available to non-public schools in the same manner as under Section 1117 of the Elementary and Secondary Education Act. All that means is that the money in the Governor's Fund and the Elementary and Secondary Ed Emergency Fund will be distributed through equitable services the same way that you get your regular title services when you participate in the ESEA title funds. So 2 new buckets of money that will be handled in the same way as you're used to through the ESEA. In other words, the local education agency is going to be required to consult with non-public schools, and the control of funds is maintained by the LEA. That means that your school will not receive actual money, it will receive services, equitable services, in accord with the amount of money that's in the pot for those 2 particular funds. Next. So I wanted just to point out the Governor's Fund has specifically mentions early education, so that is there for your reference. And then number 2, the allocation of the funds for the elementary and secondary emergency relief fund. That's going to be the same proportion that each state received under Title 1A in the most recent fiscal year. And the law authorizes 12 uses for the funds. Next. So let's talk about this a little bit. I am not going to be able to read every single one of these. You're going to be able to go back and look at these later. I thought I would highlight the ones that I thought were most useful to you in particular. So not the Governor's Fund, but now under the Elementary and Secondary Emergency Relief Fund, it has 12 authorized uses. Number 1 of those 12 is any activity authorized under ESEA. That simply means any of the title services that you've already been participating in, they're going to get more money just in that number 1 item. They'll get more money. So if you're already in, you've already said you're going to participate, whatever it is that you're doing, the funding will go up for that and you can continue to do that particular process. I thought number 3 would be useful, provide principals and school leaders resources to address the needs of your individual school. Thought number 6 would be handy, training professional development for sanitation. 7, providing supplies to sanitize and clean the facilities. Next slide. Number 8's got a line in there about providing technology for online services, ensuring educational services can continue to be provided so that you meet federal, state, and local requirements. Number 9, educational technology. Again, bear in mind that the LEA will own it if they buy it for you. Next slide. 11 and 12. Number 11 has summer learning and supplemental after-school programs. That may be helpful to you. And number 12 is kind of a bucket of everything else, other activities necessary to maintain operation and continuity of services and to continue employing existing staff. So next slide. So that gives you an idea of where we're going in terms of that particular fund. For both the Governor's Fund and the Elementary and Secondary Ed Emergency Fund, you need to reach out to your local education agency right now about participating in either one of those 2. Equitable services flow for both of them flow through the LEA. Equitable services require consultation with non-public schools, so you need to talk to your LEA about what it is that you need. We've alerted the Department of Ed that there's going to be a lot more interest, more than likely, in emergency programs like this than there would be usually under the standard ESEA programs. And the idea is that, you know, our hope is they'll alert the LEAs eventually to that reality so they're ready for you. Next slide. So here are some things to think about. And I'm going to go through several of these. We're going to jump between the 2 funds a little bit. So I'll try to be logical for you. The CARES Act Education Stabilization Fund is not a Title I program itself. That is the method, that's the way the funds will be allocated. Your previous non-participation, if you didn't participate in title services, that's not relevant. If you don't know who the key personnel at your LEA happen to be for dealing with this, suggestion might be to ask neighboring schools and others in your region who those key people are if you haven't participated in the past. You should talk to your LEA about what you need before they apply to the separate governor's emergency fund, right? Because the LEA is going to ask the governor for money from his fund. You need to tell the LEA, here's what we need. Make sure the LEA counts all of your children in the grant application. All children are eligible to participate in this program. It's an emergency program. So it's not just the Title I children. So all your kids should be counted so that when the percentages are determined by the LEA, our percentage will be at the right level. You should tell the LEA that you want to be consulted with prior to your applying. Use the list of 12 items to craft what you might need from them. So I'll just bear again from under the elementary and secondary fund, 12 lists, 12 items, pick those that fit. It's worth noting that what the public schools may need and the private schools may need, they may differ, may not be relevant what the public schools need. So the LEA is going to need to be able to take into account what you need. Services are determined by consultation. And I have to give credit to my colleague, Jennifer Daniels at the Catholic Bishops, U.S. Conference of Catholic Bishops for coming up with this term, but she said this is not a matter of being consultold by the LEA what you're going to get. It needs to be a genuine consultation. So let's move to the next slide. Remember, your ombudsman is a possible resource in a difficult situation. I brought this up last time, but it may be that that person isn't going to be want to be pulled into Education Stabilization Fund questions, even though the CARES Act specifically refers to the section of the ESEA, which includes ombudsman. However, if you're using item number 1, that is the ESEA, and the ombudsman is required to help with that particular one. So I'm thinking that the ombudsman ought to be available to assist in the others. I just wanted to flag that for you. You can assume that your LEA would not provide services under number 1 if you'd already declined to participate. That's logical. If you did intend to participate, then number 1 does apply to you. So it's worth noting also that items number 2 through 12 likely include anything you would have sought through the ESEA, and potentially because of this emergency situation, there may be fewer requirements. Next, please. If you did participate in ESEA title services, there's a tweak here that I just want to flag for everyone. Be aware that states transferred money from Title IV into Title I over the last year or so because they wanted to use more of the funds for that. It may be that they're putting the Title I money back into Title IV. That's because Title IV deals with some of the computer technology issues. So it's important now to ask if there is a Title IV allocation. So imagine you told the LEA originally back before all this started that you weren't going to participate in equitable services for other titles, but you wanted to participate with Title IV. And then boom, the money was taken out. And so there was nothing for you. That money may be back now. So you'll want to just follow up on that. Next, let's think about the Governor's Fund. That's a good place to look for services that simply aren't in the list of 12. So you want to work with a state coalition to identify the needs of the non-public schools and submit that list to your governor. So where you have a friendly governor and a school choice program, would encourage you to seek resources for that. In some states, CAPE, the Council for American Private Ed, and the non-public schools came all together to do just that. Illinois was a great example of that. As part of outreach to the governors, it's worth reminding them that they have an obligation to offer equitable services to non-public schools. So don't let them forget that. And then in terms of how you're going to make this happen, reach out to your state ACSI coalition, if your state has one, to your state CAPE, again, if your state has one, or to your state's Catholic conference, if there is one, or other organizations that you know of. Work together, so if you don't already, in order to approach the governors with a united ask. Next screen, please. So this is the screen from last time, and I'm just going to leave it on this note. If you do have concerns or questions, the Office of Non-Public Education has a great website. You can go there for information, and then of course the Ombudsman directory. If you're going to be needing them, there is one for every state, and that's the link for you. So you can go back and look at these and review the 12 items, and hopefully this will be of some help to you. Thank you. And so Tom, I will turn it back over to you now.
Sorry about that delay there. It just took a little bit. I want to just remind you of just a couple updates on the Families First Corona Response Act. And again, I have to remind you, because we get a lot of questions about this. This bill intent was to provide those who are unable to work or telework due to various qualifying reasons to get the emergency paid sick leave or the emergency FMLA. So again, just because your school is closed does not automatically qualify your employees to be able to get either the emergency paid sick leave or the Emergency Family and Medical Leave Act. So again, employees that have been laid off, and as I mentioned last week, you've laid them off before the April 1st, they're not eligible. And again, so just remind, if your school was just closed before April 1st, and even though you've got people working at home, you've got some that are not working, they are not eligible, those that are not working. Last week I mentioned there is this exception. People asked, about the exception for 50 employees. I talked about this last week, and these are some of the qualifying reasons that you can be exempt. So it says that a small business must claim this exemption if an authorized officer of the business has determined that. So last week I brought up that we didn't know if that meant that there was going to be an application process, if there was going to be a decision by the Department of Labor or the Secretary to make you exempt. And the guidance that came out this week said, no, you will just make that determination. The authorized officer makes that determination whether they're exempt or not based on these one of these 3 points. And then also it says, a small business is exempt from mandated paid sick leave or expanded family and medical leave requirements only if you have fewer than 50 employees and that leave is requested because of the child's school or place of care being closed or child care provider is unable due to the COVID-19 related reasons. So it doesn't exempt you from the other qualifying reasons. In other words, the COVID reasons that would be an employee staying at home because they've got the virus, an employee is unable to work, you've got work for them to do, they're home because they're taking care of a loved one. Those reasons you cannot be exempt from. The only reason you could be exempt is for this one piece of people not being able to work because they're children. An authorized officer of the business, once they've determined that at least one of the 3 conditions on the previous slide in question is all they need is satisfied, then they're exempt. I do want to, there's no application for approval. The authorized officer just makes that determination based on the criteria I mentioned. There is required documentation. You need to document that you are doing it, that you're taking advantage of the exemption, and that you must still post the federal poster mentioning it to employees. As we talked about before, there is a federal notice that you send to all your employees, and we recommend normally you would post that in your teacher lounge or somewhere else, but now you need to email it to every one of your employees, and that's available on their website, on the DOL's website. I believe we have a link to that on ours also. Remember, the exemption though only covers employees staying home to take care of their children, so that's the only part you could be exempted from providing that paid sick leave or FMLA for that area. You cannot be exempt for the other COVID qualifying reasons. And again, the new guidance that we posted on the website today on FFCRA has more details on the exemption. And there's also, I would just remind you, this website that's here, that is the Q&A on the Department of Labor website that they continually update. It first started out at 21 questions. It's now up to 79 questions and answers. So that's a great place. If you got questions you're not sure of the answer to, go and look at there. They're really clear on different scenarios and being able to give you some answers. Now let me jump over to the CARES Act and the Paycheck Protection Program. As you know, and I'm not covering the details. We covered all the details in last week's webinar, so you can go back, listen to that, or look at the notes, the slides from that. But these are some changes and some more clarification on that program. As you know, schools were able to start applying, or small businesses, as of last Friday, and we're hearing all kinds of different things, that some banks aren't doing it. We've heard that some banks are only doing it for those that are actually have a relationship with them. Some banks have already said we've already processed as many loans as we're allowed to. We've reached our limit. So again, you just need to keep checking with your bank and working with your bank on that. But these are some new areas of guidance. Number one, the interest rate in the new guidance went from 0.5% to 1%. So this loan has an interest rate of 1%, and it must be paid back over a 2-year period. Previously, they had talked about a 10-year period. They've moved that to a 2-year period. So if you're not able to get loan forgiveness, then therefore you would, whatever amount you borrowed or whatever you haven't been forgiven, you will have then 2 years to pay that at 1% interest. Loans based on the previous year's monthly salary. So in there, it's going to ask you to figure out how much you can borrow, and that calculation, there's been all different things floating around, but most banks are asking you to provide what would be your average monthly salary during the year of 2019. So again, you can figure out your monthly salary, plus then you add the benefits to it to come up with all the benefits that the employer paid, and I covered that last week, to figure out that average monthly salary. Now also, they've made it real clear that the school must use at least 75% of the loan for payroll costs for forgiveness. No more than 25% of non-payroll expenses can be used for that loan. So if you are, so here's an example. Let's say you borrow $100,000. You then have 8 weeks to spend that $100,000. If you do not spend it all, then whatever that you don't spend will have to go be paid in a loan. It will not be forgiven. But let's say you have to spend then at least $75,000 on payroll, and you spend $25,000 on utilities and rent or mortgage interest, the other qualifying reasons. As long as you've spent less than $25,000 on those non-payroll expenses, it all can be forgiven. But let's say instead you spend $65,000 on payroll and you spend $35,000 on the utilities, rent, or mortgage interest, then anything over 25% would not be forgiven. So that you would still owe $10,000 back to the bank, and you'd have 2 years to pay that back with 1% interest. Let me just mention, there are some other programs we did not talk about last week. I do want to hit on those. There's a lot more detail listed on some of the guidance we've given you on the website. I don't have time to go into details, but just so you know that these are available. Number one is what's called the deferral of payment of employer's share of Social Security taxes. And if you have your PPP, that we just talked about, loan forgiven, then you cannot apply for this. But it allows you to defer your Social Security taxes that you pay all the way through December. You can defer those actually to part of them to 2021 and part of them to 2022. And it's only the employer portion, 6.2% of those taxes. So again, you can look at that and see if you would qualify for that based on what you're doing with the PPP loans. The second one is the employer retention credit for employers to closure or substantial revenue loss. Again, it gives you a refundable credit towards your payroll taxes if you are fully or partially suspended your operations due to orders from the government, or you exercise a reduction in gross receipts of at least 50%. And again, there's more qualifying factors and how you compare what those losses are. So again, if this is something you're interested in, you will need to spend some time looking at the information that's been put out about that, deferring again, or giving your taxes, even getting some credit there. So again, those are two programs. There's lots more guidance coming out on those, but you want to go ahead and take a look at those two programs on the government side or on our side. Then the last one I just want to mention, we've gotten a lot of questions about the economic injury disaster loan. And this is a loan that the Small Business Administration has been doing for many years. And it's basically a low interest rate loan that provides up to $2 million in assistance for small businesses that can be used to pay for immediate expenses during an emergency. So this is money that could be used during a hurricane or a tornado or some other declared emergency. And so with the coronavirus being a declared emergency, they have opened up these loans to be used for that purpose. And again, it's only for 500 employees or less. And the eligible applicants who apply for this relief loan may request up to $10,000 be immediately dispersed. That amount doesn't need to be repaid regardless of whether you get the EIDL loan or not. If it's approved, the $10,000 is to be provided to you within 3 days. So it's sort of an immediate, quick money if you really need it. So again, you'll see a lot of literature that says this loan is not available, and it typically is not available to religious organizations. But the SBA, the Small Business Administration, has made it very clear that this loan also now can be used for religious organizations. So if this is something you're interested in, I've already talked to several schools that have applied for this loan and apply for that $10,000 immediate dollars. So again, you might want to take a look at this. This is different than the payroll protection loan. So again, you want to take a look at that loan also if you're interested. So at this point, I'm going to stop right there, and I'm going to turn it over to Philip Scott. Philip's our in-house counsel here at ACSI, and he's going to share some about what about the questions on, the forgiveness, and is there strings attached? Well, Philip's going to give you the answers to all that. So Philip,
Thanks, Tom. Thanks, George. So over the weekend, the SBA, the Small Business Administration, released new guidance specific to religious entities. And so that's what we're going to hit in a significant part. Really, the framework I want to approach in the two big questions is, what are the restrictions and how long do the restrictions last, right? And so I'm going to address those in opposite order simply because the how long answer is the easy one. The guidance that they have provided says the restrictions that will be applied to you are only in effect as long as the loan is either in repayment or up until the point that it's been forgiven. So we don't know how the forgiveness portion is going to work quite yet. Does that mean, they're basing that on the first 8 weeks of spending after you get the loan? Does that mean in week 9 you can apply for forgiveness? I don't know. But as Tom mentioned, the loan period is going to be set at no more than 2 years. So that how long question is really going to be anywhere from 9 weeks to 2 years, right? Depending on when that loan is repaid. There's no penalty for prepayment if you decide you don't want to do the forgiveness or the whole portion of the loan doesn't apply for forgiveness. The other aspect, and this is an important one, is the facilities that your school has. So in the program, the CARES PPP loan, you can use part of those monies for either rent or interest on a mortgage. Our strong suggestion is you do not use money on either one of those. One, because there's the 25% limit that Tom talked about, but secondly, and more importantly, there's the potential that under the rules that money spent on property, so real property, meaning land or buildings, or personal property, meaning things like a computer, that these strings attached to that for the life of that building or that computer. So just be aware, our strong suggestion is you don't use this money on any property. Use it instead for payroll. So what restrictions apply to these loans? In the application themselves, there are 3. We're going to cover those 3 and then hit some other ancillary ones that apply also. So the first one, Title IX, would apply to those who are recipients of these loans. Title IX prohibits sex discrimination, right? It requires equal treatment of men and women. Now, under the Obama administration, they expanded the definition of sex to mean gender identity. The Trump administration has rolled that understanding back, and they have reinstituted the plain meaning of it, what was intended when the law was passed back in the 70s, which is simply sex discrimination means male, female. And so as of today, we don't believe there's SOGI implications in what is being asked here. Now, what does that mean for the future? The Supreme Court has cases in its docket. At some point down the line in the next year or two, it could modify the quote unquote definition of sex as it applies in some of these regulations. If Trump loses the next election and you have a Democratic president who comes in, they can do just as Obama did, then Trump overturning that, they can then overturn the Trump rule. So this is not concrete, but as of today, as of right now, and in the near future, sex means male, female, but it could down the line mean gender identity. So the takeaway is, if you're going to do the loan, make sure, again, going back to that first question, how long, that we either pay it back quickly or we have gone through the forgiveness period quickly. We don't wait around for that. Next slide. All right, 2 other sections that are specific to the application itself and what applies to you. The other is going to be Age Discrimination Act of 1975, which essentially says, you see it on the screen, prohibits the discrimination on the basis of age. We already do this as schools and as churches, not something onerous there. I should mention real quick too, I forgot to mention this on the Title IX aspect, there's also a specific religious exemption that you can apply for. And so we don't have the time to go through it, but there's a specific exemption for religious entities as it relates to Title IX. So sorry about that. Next. So age discrimination shouldn't be a huge hurdle. Title VI of the Civil Rights Act of 1964, it will limit discrimination on the basis of race, color, national origin. Again, not a heavy bar here. Most of our schools have been doing this already under some of the, or at least for the most part, not entirely the same, but very similar in regards to IRS regulations for faith-based schools, have a similar non-discrimination on the basis of race, color, and national origin. Now, where the SBA loan modifies this is they go on to add religion, sex, marital status, handicap status. And again, sex here does not mean gender identity. It means male, female, distinctive. Where this comes into play is not going to be with membership. It is not going to be in employment. It will be rather in services that are open to the general public. So we'll get more into that. But for the time being, there is, again, a religious exemption for Title VI, and you've got it there. I won't read it to you, but essentially for educational institutions and religious entities, there's protections on membership and employment that is related to the missional, or rather the religious aspects. So this is a bit narrower, but it's still a fairly strong protection there, that if you're hiring somebody and it's in the furtherance of your religious activities, then you've got some exemption there. Next. The last one I want to hit is not included in the language of the application or in the SBA regulations, but it will apply, and that's Section 504, which is the original non-discrimination on the basis of disability. ADA has kind of come along and superseded that in a number of ways, but there's still a number of Section 504 aspects in particular that apply to the education side of things. And so 504 would apply to you for the length of this loan, again, or until the forgiveness aspect is acted upon. In this way, in that if a student, it would apply to you in admissions, is the most implication. And what I mean by that is, if a student with a special need or disability applies for your school, you simply cannot deny them because they have the special need or disability. I don't think most of our schools are doing that anyways, but this would apply. Your duty then would be, if the student has a special need, they make it known to you, you have to meet that student's need up to and including minor adjustments. And I have minor adjustments in quotes, that's part of the language there. And essentially that means a financial obligation, right? So if your school is not set up to take, as an example, if your school is not set up to take a student with severe autism or a severe need where they're going to have as an example, aides follow them around, they're going to have a special pullout and all the rest, and your school has not set up those type of programs, it's likely you're not going to have to meet that student's, you're going to be able to say, I'm sorry, but we simply don't have the ability to meet the student's needs here. This is more than just a minor adjustment to meet the student's needs. So Section 504, again, high level, but that's what we're looking at there. So those are the primary restrictions that are going to apply to you if you apply for these loans. The question is going to be, do you as a school feel that you're able to do that you're able to accept those standards, those things that are upon you for that limited duration? If the answer is yes, then you've got one path. If the answer is no, you have a different path. I do want to wrap up this particular portion just talking about the SBA guidance. I think it's fairly good guidance. It doesn't answer everything we have, but it goes a long way. And so where we're at the moment, I think we have the answers to some questions. There are other questions we don't have answers to, and we likely have as much as we're going to know in the meantime while there's still an opportunity to apply for the loans. My suggestion would be on the ACSI website, the coronavirus website, we do have the SBA questions and answers. We also have 2 papers that we've written on our sort of assessment of that. Goes into a little more detail of what I've just shared with you. But essentially, to boil it down, the SBA guidance talks about, it clarifies really that its intent is not to limit standards or responsibilities, duties that you put onto members or that you put onto those that you are employing when it relates to the religious aspects of what you do. Where it does come into play again is when I talked about services. So, you know, the typical example, the soup kitchen. If you're gonna have a soup kitchen, it kind of has to be open to all these groups that we've just gone through. Again, usually not a problem. When it comes to admissions for a school, though, where this may come into play is for schools that are more of an open admissions, missional type of enrollment. Some of these may come into play, again, as we have talked about them and to the extent we've talked about them. I don't think it's anything that's out of the realm of possibility or things that we can't do or unwilling to do, but again, it's going into it and making the assessments up front on what the impact is going to be. All right, next, we're going to shift gears a little bit, talk about something we haven't hit too much on, but I think it's important, and that is state educational issues. So put the federal CARES Act on the side for a moment. I want to shift gears and talk a little bit about state and federal mandates for education. About 2 weeks ago, the big discussion was the U.S. Department of Education coming out and saying, essentially, we're going to give state testing waivers to schools that ask for it. Well, that has or should have little impact on us as private schools. And here's what I mean by that. The federal mandate for state testing, that's the high stakes testing, right? So a state creates its own curriculum and then develops its own state specific tests to see is the curriculum and student attainment being fulfilled. It then turns around and has to turn those state testing assessments, the grades, the yearly progress of those students, all that has to be turned into reporting back to the federal government, which then becomes the basis of, do you get federal funding or not, school district. So a big deal from that standpoint. And so the waivers are significant in that the U.S. Department of Education is not going to be asking for all these same standards to say, do you get funding this year or not from the federal government? That is primarily a public school question, right? The thing we need to look more to as private schools is the state question. And what I mean by that, things like seat hours and days of instruction. If your state has a mandate that 185 days of instruction have to take place within a school year, and for each of those days, at least 5 hours has to be instructional time, that's a standard that still applies. The state has to waive that, not the federal government. And so a couple of questions that come up that we need to be cognizant of as we're going through this process. Have those state requirements been waived? Okay, if they have, has it been just the public school or does it also include private schools? Another aspect, some states will not count online educational efforts, right? So if there's a seat hour requirement, your state may not allow the online education that you're doing from home to count. Again, that's a question. What do we know what the implications are for us? The big one is going to be for school choice states. In many of the school choice states, and we're going to come out with further guidance on this in the next week, but in many school choice states, there's a testing mandate. Again, this is apples and oranges. We are not talking about federal high stakes testing that is tied to federal funding. The vast majority of the time when we talk about school choice testing, it is a normed reference test, the type of test we give to students, right? So it could be the Terra Nova, it could be the Iowa, it could be various other tests that are required as part of reporting for the state. It could be a tax credit program, could be a voucher program, could be for state athletics. There are a number of areas where these come into play. Simply because the federal government has waived those does not mean that the states have waived those for us as private schools. And so we need to be cognizant of that and be aware of that next. So a few problems, I think, things we're going to have to address on the state level as we're looking into how this school year is going to finish. Again, on the school choice side of things, even if the school, or rather the state waives school requirements for things like seat hours or testing and all the rest, we need to make sure that our school choice programs are actually under the authority of the Department of Education. What I mean by that is some of these school choice programs are actually written into the tax code. And so it's actually the Department of Revenue or the Department of Taxation that has control and the regulations over these school choice programs and what schools have to turn in. And so again, if we're going to have waivers, it's probably going to need to be done in conjunction with some of these other departments, not just the Department of Ed. And so there's probably, we're going to have to do our part to educate folks on the state level, because there's going to be a lack of awareness issues, right? If you're going to waive things for the state, does that apply to private schools? That's question one. And then two, does your waiver include the private school specific requirements? And they may not. And so we need to do our job to make people aware, make our local governments, our state governments, our elected officials aware that these are issues that they're going to need to address. Why this becomes problematic, for one, a lot of the Department of Educations have shut down or sent people home to work from home. Those that are still operating are really focused on the public schools at this moment. They're going to be shifting to Georgia's material with these emergency funds as well. So we need to be aware of this. A lot of the legislators have shut down for the year as well. They decided to close up shop. So we're going to have our work cut out for us. I think at this moment, what we're suggesting is don't cancel your testing and don't cancel your other state mandates, things like attendance collection and the rest, until we know what we have on our hands. You don't want to be dismissed from next year's program simply because you didn't do the work this year. You thought it applied to you when maybe it didn't. We're also need to do the work to start informing elected officials and finding out what are they doing and what are they thinking. Next. The last thing I want to bring up is now that we, initially we were thinking this 2 to 3 week phase, this emergency quick closure, that has now shifted into 4 weeks, 6 weeks, the end of the school year. And so with that shift also comes, I think, a revisiting and a reemphasis that we want to do things well and better as a movement. Part of that is the privacy and security questions. And so for your use and for your knowledge, we've posted 2 new resources as well this week, a virtual classroom policy update that you can send to parents. We also suggest that your technology use and privacy policies that you have, you probably need to revisit them at this point and see how they need to be updated with this new reality of distance learning. We also have an article that covers a lot of these areas, including, what are the security issues in Zoom, student privacy, child safety, what are the things you need to be thinking about and implement as we finish out the school years largely from home. So with that, I will stop here. Here's our email address and our ways to contact us if you have questions. And from here, we're going to shift to answer some of your questions that you've submitted.
Thank you, Philip. We do have a number of questions that have come in and that were submitted previously. And so I would ask all of our panelists to join us at this time. Our first question here is for Tom. Tom, in regards to the PPP loans, if we reduce our staff by laying off hourly and part-time employees, will we be penalized in the payback for the SBA loan?
If you have laid off your, let's say your support staff because there's nothing for them to do and your teachers are working online teaching classes, but you don't have any jobs for your support staff and you've already laid them off. If you get the loan, you want to, again, the look back is the previous years for the amount you'll get for the loan. So that'll be 2019. But you'll want to, as soon as you get the loan, redeploy those employees, bring them back on, give them jobs to do so they have the opportunity to be working. The purpose is to put people back to work for that loan. So that way, when it comes time, because what you're going to do is you're going to have to compare your payroll at the end of that 8 weeks to the year before that time. So if you've got less people working, then you're going to get less forgiveness. So the best thing is to bring them on, redeploy them. There's plenty of things that you could have them do in supporting teachers and calling families and helping do online things like that. So yes, you need to get them back on the payroll if you get the loan.
George, there's a question for you. It deals with the area you discussed. And can a school use the emergency education funds to, let's say, pay for a counselor to help with students through this time?
I'm going to say I'm not entirely sure. That would be something I'd want to look at. If it can be fit into one of those 12 items, then yes, you could make a pitch for it. The trick is it's equitable services, so that counselor would be provided by the LEA. So you could certainly talk to the LEA and say, hey, I need a guidance counselor, and they will provide that service for you. See what they say.
Yeah, and if they don't have the service, we could ask if they would pay somebody to do it, and then we could pick the person, because we would want somebody that's giving some Christian counseling versus a person from the public school district.
There's several questions that ask about the unemployment and insurance program, and I know, Tom, you talked about that a little bit last week, but can you just kind of run through what are the aspects, particularly for those schools who don't participate in it now?
Good question, and we do have new guidance on that. It's in our guidance document on the CARES Act, so be sure to check that out. But basically, for those schools that are church-sponsored, typically your employees are not covered by unemployment. And then independent schools who may use that reimbursement method rather than paying taxes. Basically, what this new CARES bill does is it covers those employees where they wouldn't have been covered before. Now, the details on how that will all work has not come out yet. But know and encourage your employees that are not working to apply for unemployment right away. From what I'm hearing, it's a pretty lengthy process right now with so many people applying. So I've encouraged them to apply. All the details will eventually come out, and basically the government is saying they're going to take care of those people so that they do get unemployment when they typically would not be eligible for it.
Philip, I have a question here for you in regards to the school community. What are your recommendations regarding communications if a teacher or a teacher's household member contracts COVID-19?
Yeah, there's a couple duties that you're going to owe both to your employees and to the families there, that they have so for on the employer side, an OSHA requirement is going to be that you have a safe working environment. And then on the, you're going to have, OSHA doesn't say this, but you're going to have a similar corollary type of rule for your families that are in the school as well. And so if you know, it doesn't matter if it's an employee, could be a parent, could be a student, what have you. If you're aware that they've contracted COVID-19 or been exposed to it, let's start with the contracted. You should be reaching out to your local either county or city health department and working with them. They are likely probably already running people down to see where the relationships are. If you're in a bigger metropolitan area where the outbreaks are fairly significant, they may not be doing this quite the same way they were before, but that would be the first stop, is to check with your local or city or county health department. From there, our suggestion would be that you do let families know that there has been some exposure. And here's the key thing: whether it's a faculty member, whether it's a family, whether it's a student, you don't identify or give out information to identify who it was. You simply say, if you've got 30 students in the high school, you probably won't even say it's the high school. But if you have 300 students in the high school, you might say, there was a student in the high school who's been exposed, et cetera, et cetera. The school is following the CDC guidelines. The school is following the county health department and local guidelines as well. Here's what we're doing. Here's what we've asked the family to do. And then on the side, you find out, again, this can be done in conjunction with the health department, but it could also be done with the family. Who has that family been in contact with at the school? And then you can reach out to them on a one-on-one basis to say, hey, again, we're not identifying who it is, but they have identified within the last 2 weeks they've been with you, right? And so you probably should self-quarantine. We're certainly asking you as a school not to come back to the school until that 2-week period and you show no symptoms type of thing. The showing no symptoms and showing up at school is not so much an issue now, as most states have canceled in-person education. Where it becomes more of an issue is with the child care or the early ed programs. A lot of those are still operating, and you're going to go through that same process here.
Follow up to that, What if the school hasn't met physically in the past 2 weeks? Does that communication still need to be provided to school families and faculty?
I think I would go back and ask who in the school community have they been in contact with in the last 2 weeks? And if there's not been any and the school hasn't met in the last 2 weeks, I would think there's probably reason not to call into question whether we need to do that or not. I think at that point, at least I would work with the family to say, okay, here's what we're asking of you, right? Not to come in contact with anyone in the school family. If you do, let us know, but that is our request. And if we go, let's say we're going back to school, the plan is on the 15th. We're going to ask you not to come back until you've had 2 full weeks, and again, there's no symptoms. But again, there is, the CDC has specific guidance that it has given interim guidance for K-12 and early ed programs. I would go look at that as well.
Thank you.
Tom, this is probably a question for you. It says, if we receive funds via the PPP, can you use those funds for expenses that occur even after June 30th of 2020?
Yes, the simple answer is yes, you can. So if you, the idea is you get the loan, and the loan, there's qualifying reasons to get the loan. And then again, you're allowed to use the loan for payroll and other things, although, rent or mortgage interest, utilities. So the idea is that first 8 weeks is the only amount that will be forgivable. So if you decide you're going to keep the loan longer and not have forgiveness and not use it all in those 8 weeks, yeah, you can use it all the way through December 31st, 2020.
There's a question here, talks about this is to my portion, it mentions, I mentioned that the dollar should not be used on property to reduce long-term ties. What about paying loan interest only and no principal in the property? So the loan itself, the PPP program, at least in the repayable part, only allows interest and not principal. The point is a valid question. I think the answer is we don't know, right? This regulation has been in the SBA for years, and the SBA has been giving out loans for years. And so there may be a history there of how they've interpreted it in the past. We don't know at this point. What I would say is with that history, I'm going out on a limb here, but I would guess there's not been any SBA loans given out that would pay 100% of any mortgage or property outstanding cost. Yet, with that in mind, there is still this language that if dollars from an SBA loan goes towards real property or personal property, land, buildings, or other property, that the non-discrimination rules attached to that for the life of it. And so I would prefer not to even go down that road. So the quick answer is we don't know. But I think the guidance is better not to take the chance.
Thank you, Philip. As we kind of round the bend here, I'm going to let Philip choose our last question here, but I want to give those of you who didn't get a chance to answer our poll at the beginning to do so now. And I also wanted to let you know that in the chat panel, I am providing a link to the legal homepage where you can find all of these resources. Philip?
So last question, and Tom, this goes to your section. How is the loan forgiveness of the PPP calculated? What are they basing your forgiveness on?
It goes back, there's some pieces there. Number one, they want to know, again, the purpose is to keep people employed. So they're going to look at your head count. Have you reduced your head count during the period from February 15th to June 30th of 2020 as compared to February 15th to June 30th of 2019. So that's the first thing you're going to look at is head count, because they don't want you cutting people if they've given you a loan. Number two, they're going to look at the dollars. So how much did you spend in payroll and benefits from February 15th of 2020 to June 30th of 2020 as compared to February 15th of 2019 all the way to June 30th of 2019. If they see that you've spent less and it's more than 25% less, then they're going to reduce the amount that you can be forgiven. So that's the comparisons that they're doing. And again, there's some little bit of lack of clarity on that, but I think that's pretty much the way we're looking at it right now, is the way that they'll look at that loan forgiveness.
Thank you. Well, I want to thank you once again for joining us. As a reminder, you can find the presentation from today along with the recording if you had others that were not able to attend. That'll be up on the legal page starting tomorrow. And we do encourage you to join us again next time. So thank you so much, George, Tom, and Philip, for your time and for your effort in putting all of this together for our schools. And to our schools, thank you for joining us. And we look forward to having you with us again next week.